Respected Principal Ma'am, Honorable Faculty Members, and my dear friends, I, Sofi Rubeena, take this opportunity to welcome you all for the dramatic presentation of Triple Talaq case decided by the Honorable Supreme Court in the landmark case of Shayara Bano versus Union of India 2017. The matter refers to 3 instantaneous talaq given by the husband named Rezwan Ahmed to his wife Shayara Bano. Mr. Rezwan Ahmed used to demand and abuse for dowry from his wife Shayara. However, when the same has been denied by her and her parents, Mr. Rezwan Ahmed got annoyed and out of anger gives triple talaq to his wife. Shayara then approaches the Honorable Supreme Court to challenge the validity of triple talaq on the ground of violation of fundamental rights. The facts and the court proceedings are depicted in the present drama in 3 parts, that is, nikah, divorce, and court proceedings. Kindly observe and appreciate.
से मकदारे महर रुपए 5000 सिक्काए राजुल वक्त 2 गवाहों की शहादत में दिया जा रहा है। क्या आपने कबूल किया?
जी कबूल किया।
शायरा बानो, आपका निकाह रिजवान अहमद से मकदारे महर रुपए 5000 सिक्काए राजुल वक्त 2 गवाहों की शहादत में दिया जा रहा है। क्या आपने कबूल किया?
जी कबूल किया।
शायरा बानो, आपका निकाह रिजवान अहमद से मकदारे महर रुपए 5000 सिक्काए राइजुल वक्त 2 गवाहों की शहादत में दिया जा रहा है। क्या आपने कबूल किया?
जी कबूल किया।
रिजवान अहमद, आपका निकाह शायरा बानो से मकदारे में रुपए 5000 सिक्के राजुल वक्त 2 गवाहों के शहादत में दिया जा रहा है। क्या आपने कबूल किया?
जी कबूल किया।
रिजवान अहमद, आपका निकाह शायरा बानो से मकदार
शायरा, शायरा, मेरी फाइल कहाँ है? शायरा, अब ये फाइल किसी काम की नहीं। आपको पता है इस फाइल की वजह से मेरे बिजनेस में कितना लॉस आया?
क्या हुआ? क्यों झगड़े आप?
देखो ना मम्मी जी, एक काम ढंग से नहीं करती है, चाय की पी वाला ही नहीं।
क्यों बहू? मैंने फाइल रखी थी उदय।
मैंने आपके पापा से जो पैसे मांगे थे वो लाए आपने?
मेरे पापा बहुत गरीब है, वो इतना पैसा नहीं दे सकते।
नहीं, ये सब नहीं चलेगा। एक तो पैसे लाओ, ये तो हमारे घर से निकल जाओ।
समझ करो।
नहीं नहीं नहीं, एक तो पैसे लेके आओ, फिर बाद में हमारे घर आना।
13 साल हो गए आपकी शादी को। हमने जो दहेज मांगा था वो लाओ, नहीं तो अपने बाप के घर निकल जाओ।
निकल जाओ हमारे घर से। मम्मी, मुझे दूसरी शादी करनी, मुझे शायरा को तलाक देने का है।
लेकिन वो तो चली गई, अब कैसे दोगे आप तलाक?
मैं उसे एक लेटर लिख के भेज देता हूँ। तलाक तलाक तलाक।
क्या हुआ? इतना रिजवान ने हमें तलाक दे दिया। रिजवान ऐसा कैसे कर सकता है? अभी अब क्या करें? तू टेंशन मत लो, मैं तेरे बापू को फोन लगाती हूँ। टेंशन मत ले, तू वो मत। हेलो हेलो, किधर हो तुम?
हेलो,
देखो ना, रिजवान ने तलाक के पेपर्स भेज रहे हैं। जल्दी आओ तुम घर पे।
रुको, मैं आता हूँ।
तू वो मत। देखो ना, रिजवान ने तलाक के पेपर्स भेजे हैं।
क्यों?
रिजवान ने तलाक दे दिया।
चलो मैं रिजवान।
नहीं, रिजवान के यहाँ नहीं जाएंगे, हम काजी साहब के यहाँ जाएंगे। काजी साहब के यहाँ चलते हैं। चलो काजी साहब से बात करते हैं। अस्सलाम वालेकुम रहमतुल्लाहि व बरकातहू। काजी साहब, देखो ना, रिजवान ने तलाक के पेपर्स भेजे हैं।
रिजवान ऐसे कैसे कर सकता है?
हाँ ना काजी साहब, मेरी बेटी का कैसा होगा?
बट अभी तो तलाक हो गया, अभी कुछ नहीं हो सकता।
काजी साहब, कुछ तो कीजिए ना।
नहीं, अभी कोई चारा नहीं है, तलाक तो हो गया।
तैयार नहीं हुई?
हम नहीं आ सकते,
हमें बाहर जाना है।
हमारे शोहर ने हमें तलाक दे दिया है।
क्यों? वो ऐसे कैसे कर सकता है?
क्या करें अब?
तुम परेशान मत हो, मेरे पहचान की एक आलिमा है, उनके पास चलते हो, हमारी मदद जरूर करेंगी।
चलो।
अस्सलाम वालेकुम आलिमा।
वालेकुम अस्सलाम।
ये मेरी सहेली शायरा है, इसके शौहर ने इसे तलाक दे दिया है। ये बहुत परेशान है आलिमा, मुझे आपसे बात करनी है उसी सिलसिले में। हमें आपकी
सलाम वालेकुम आलिमा। हमारे शौहर ने हमें तलाक दे दिया है, वो भी 3 तलाक, क्योंकि हमने दहेज नहीं दिया। हम बहुत परेशान हैं, अब हम क्या करें? क्या इस्लाम में औरतों की कोई अहमियत नहीं है?
नहीं बेटा, ऐसा नहीं है। निकाह तो हमारे नबी सल्लल्लाहु अलैहि वसल्लम की सुन्नत है और तलाक अल्लाह की जायज़ दी गई चीज़ों में से सबसे नापसंदीदा चीज़। हमारे नबी मोहम्मद सल्लल्लाहु अलैहि वसल्लम ने 11 शादियाँ की पर तलाक एक भी नहीं दिया, बल्कि उन्होंने तो तलाकशुदा और बेवाओं से निकाह किए हैं। और हमारे नबी सल्लल्लाहु अलैहि वसल्लम ने दहेज नहीं दिया, बल्कि अपनी बीवियों को मेहर दिए हैं।
तो हमें इंसाफ मिल सकता है?
हाँ, क्यों नहीं। देखो, कुरान में इस बात का जवाब मौजूद है। कुरान पाक में सूरे बकरा आयत नंबर 229 में अल्लाह ताला फरमाता है, अत-तलाक़ु मर्रतान फ़इम्साकुम बिमअरूफ़िन औ तस्रीहुम बिइहसान वला यहिल्लु लकुम अन तअख़ुज़ू मिम्मा आतयतुमूहुन्ना शैअन इल्ला अन यख़ाफ़ा अल्ला युक़ीमा हुदूदल्लाह फ़इन ख़िफ़्तुम अल्ला युक़ीमा हुदूदल्लाहि फ़ला जुनाहा अलैहिमा फ़ीमा इफ़्तदू बिहि तिल्का हुदूदुल्लाहि फ़ला तअतदूहा वमन यतअद्द हुदूदुल्लाहि फउलाइका हुमुज़ ज़ालिमून। जानती हो इसका मतलब क्या है? तलाक सिर्फ 2 बार है, यानी जब 2 तलाक दे दी जाए तो फिर औरतों को या तो अच्छे तरीके से निकाह में रहने देना है या भलाई के साथ छोड़ देना है। और ये जायज़ नहीं कि जो महर तुम उनको दे चुके हो उसमें से कुछ वापस ले लो। हाँ, अगर शौहर और बीवी को खौफ हो कि वो अल्लाह की हदों को कायम नहीं रख सकेंगे, तो अगर औरत शौहर से रिहाई पाने के बदले में कुछ दे डाले तो दोनों पर गुनाह नहीं। ये अल्लाह की दी हुई हदें हैं, इनसे बाहर ना निकलना। और जो लोग अल्लाह की हदों से बाहर निकल जाते हैं वो लोग गुनहगार होंगे। और तो और सूरह बकरा आयत नंबर 226 में भी अल्लाह ताला फरमाते हैं, और उन लोगों के लिए जो अपनी बीवियों के करीब न जाने की कसम खा लें 4 माह की मोहलत है, बस वो अगर इस मुद्दत में रुजू कर लें तो बेशक अल्लाह बख्शने वाला मेहरबान है।
तो हम क्या करें, आप ही बताओ।
एक बात बताओ शायरा, जब तुमने निकाह के वक्त, जब तुम्हारा निकाह हुआ तब तुमने कितनी बार निकाह कहा?
3 बार।
और तुम्हारे निकाह कितने हुए? 1। इसी तरह से 3 बार तलाक कह देने से तलाक भी एक ही बार होगा ना?
मुझे इंसाफ मिल सकता है?
हाँ जरूर, क्यों नहीं। तुम सुप्रीम कोर्ट का दरवाजा खटखटाओ, मैं तुम्हारी मदद करूंगी। और शायरा, तुम्हें लड़ाई लड़नी होगी न सिर्फ तुम्हारे लिए बल्कि हिंदुस्तान की वो तमाम मुसलमान औरतों के लिए जिनके साथ ये जुल्म हुआ है। और ये दुनिया को बता दो कि असल में 3 तलाक क्या है।
हमारे शौहर ने हमें तलाक दे दिया है, वो भी 3 तलाक, है ना? हाँ, आप हमारी मदद करो।
बस यही लिख के भेजा है?
जी हाँ।
इस पर तो केस होगा। चलो हम उसको
Advocate Amit Chadda accepts the brief of Shayara Bano. Here, Senior Counsel Advocate Amit Chadda accepts the brief of Shayara Bano and challenges the practice of triple talaq in the Honorable Supreme Court of India under the Article 32 of Indian Constitution for the violation of fundamental rights. The Honorable Supreme Court issued notice to all the respondents and the respondents filed their say in the court. This case created stir in our society. It took 6 days from 30th March 2017 to 22nd August 2017 to conclude the case. Now, let us see the arguments.
हम शायरा के साथ हैं। We want justice. We want justice.
होने दो ट्रिपल तलाक, होने दो ट्रिपल तलाक, होने दो। बंद करो ट्रिपल तलाक, बंद करो। आप इस्लाम में दखल नहीं दे सकते। इस्लाम में आज तक यही तो होते आया है, ट्रिपल तलाक होते आया है और
आप इसमें बदलाव नहीं ला सकते। आप सामाजिक सुधार के नाम पर आप हमारे रिवाजों को नहीं बदल सकते। होने दो ट्रिपल तलाक होने दो, होने दो ट्रिपल तलाक होने दो, बंद करो ट्रिपल तलाक बंद करो, होने दो ट्रिपल तलाक होने दो।
होशियार, राइट और
My lord, I am Advocate Singh Chadda, petitioner's lawyer, requesting the honorable court to present the case facts before it. Thank you, my lord. My lord, the key facts are as follows. My client, Bano, was married with Rezwan Ahmed in 2002. She was visiting her parents in October 2015 when her husband, Rezwan Ahmed, sent her a letter. My lord, a divorce letter. The word talaq was written thrice in it, which is nothing but talaq-e biddat. My lord, my client, Bano, urged before the court that the practice triple talaq, polygamy and nikah halala are unconstitutional and against the constitutional values. My lord, may I raise the two important issues in front of the court?
Yes.
Thank you, my lord. Issue 1 is the practice of triple talaq is an essential practice of Islam. Issue 2, does the practice of triple talaq violate any fundamental rights of citizens of India granted by our constitution? Thank you, my lord. The form of divorce recognized by the Muslim Personal Law, Sharia Application Act 1937. My lord, I also point out that several High Court and Supreme Court decisions have restricted the unilateral power of Muslim men to divorce a woman and criticize the practice of triple talaq as it does not have any Quranic sanction, my lord. Under Article 14 and 15, the Constitution of India, I urge to strike down the triple talaq as allowing an uncodified power to the Muslim man to the divorce and violence. My lord, Ms. Bano has filed false claim case claiming that his practice violates several fundamental rights under the Constitution of India. Article 14, equality before the law. Article 15, subclause 1, prohibition of discrimination, including on the ground of gender. Article 21, right to life. And Article 25, freedom to religion. My lord, I would like to focus on two arguments made by Muslim Personal Law. May I, sir?
Yes.
Page number 75, para number 2. First is that by virtue of the 1937 Act, Muslim personal law are statutory law covered by Article 13, expression law in force, and subject to Part 3 of Constitution. The Bombay High Court decision is the State of Bombay versus Narsu Appa Mali, as it includes only non-codified, non-statutory personal law from the Part 3 of the Constitution, and hence does not apply to this case. My lord, the right to religion in Article 25 of Indian Constitution is subject to other provision in Part 3, which includes Article 14, Article 15, Article 21. Hence, I challenge the practice are not protected by Article 25. My lord, I conclude by suggesting that if the triple talaq is struck down, the law of divorce for Muslim would be the dissolution of Muslim Marriage Act 1939. They could apply equal to the entire
Court proceeding.
My lord, shall I? My lord, I began the day by revisiting the concept and form of divorce under Muslim personal law. Talaq is a form of divorce where Muslim husband divorces his wife, and khula being the form where a Muslim wife divorces her husband. My lord, I would like to clarify that under Quran, after the husband pronounced talaq for the third time, the divorce becomes revocable provided he pronounced talaq for a reasonable cause and reconciliation attempt failed. Each pronouncement of talaq is followed by 3 months waiting period, that is iddat, to allow the husband and wife to reconcile and to ascertain if a wife is pregnant. If she is pregnant, the divorce is deferred until the baby to protect the interest of the child. However, if there is no reconciliation in the iddat period that follows the third pronouncement of talaq, the talaq becomes effective and revocable. In India, 90% of Muslim community are Sunni, of which 80% belongs to Hanafi school. Shias don't consider triple talaq valid within the Sunni community. Only some arguments of the Hanafi school triple talaq. As several Sunni Islamic states have abolished the practice of triple talaq, there is no widespread acceptance of the practice across the world. Thank you, my lord.
My lord, I, Anand Grover from Bharatiya Muslim Mahila Andolan. My lord, the first type of talaq is attempting independent reconciliation in which both shall try to convey the relationship and the husband shall show annoyance and refuse to share the bed with his wife. The second step of talaq is appointment of arbitrator, one from wife's side and another from husband's side. The third step of talaq is pronouncement of talaq during the period of thur, it means state of purity, and followed by iddat. My lord, the fourth step of talaq is waiting period of 3 months, menstrual courses of determined pregnancy, and also for the revocation of divorce. And if wife is pregnant, then iddat period postponed till the birth of the child, and the wife has right to live in her husband's home. During this period, husband and wife are free to revocation. My lord, the fifth step of the talaq is to finalize divorce after the iddat. If this iddat waiting period is completed without reconciliation, then only one divorce is complete. All steps, individual reconciliation, separate bedding, arbitration, iddat period, and pronouncement of talaq is thorough to be followed again for second talaq. My lord, no triple talaq found in Holy Quran and Hadith except above. When all 3 talaqs are complete by above procedures, states remarriage with previous husband possible only if she married with another man with new meher, a natural course of action. Marriage has been commenced, sexual relationship, develop disputes arise between them, divorce. All the steps of talaq as above are followed in natural course of action or divorce by any other mode. Talaq not revoked even after iddat. She becomes single. She may marry with first husband with the consent of both and new meher and witness. Naturally, which will be called as halala. Or when the second husband dies after consummation of marriage, she may marry with first husband with the consent of both, with new meher and witness. Then also, this will be called as halala. This type of intersection, talaq is called as talaq biddat. Biddat means innovation which is not allowed in Islam. That's all, my lord.
Day 3 court proceedings.
My lord, I am respondent's lawyer Manoj Goyal. My lord, the question of assessing the constitutional validity of triple talaq does not arise because a divorce is between 2 private individuals and no state action is involved. Thank you, my lord.
My lord, myself Kapil Sibil advocate from the side of respondent. My lord, I begin with the proposition that until the mandate for a uniform civil code under Article 44 of the Constitution was realized, both customs as well as personal law of communities would be protected under the Constitution. My lord, I also suggested that despite codified laws, particular customs within religious communities continued to be protected. Thank you, madam.
Day for court proceeding.
My lord, I contended that the court cannot interfere in the practices like triple talaq, as personal law is not law under the Article 13 and not subject to fundamental right review. And also, the Sharia Act 1937 does not codify substantive Muslim personal law, but restates that the Sharia shall also apply as the rule of decisions to make Muslim overriding any customs or uses to the contrary. Moreover, since marriage is private contract, under Islamic law, no state legislature can change it. The Constitutional Assembly debates to argue that the definition of the law under Article 13 does not include personal law. My lord, the Narasu Appa Mali case in Bombay High Court to argue that personal law cannot be challenged under Part 3 of the Constitution, as they don't fall under the definition of law or law in force. Also, I relied on the Krishna Singh's versus Madhura Ahid and Youth Welfare Federation versus Union of India to affirm that non-statutory personal law is excluded from Article 13 of the Constitution. I would also like to show that certain customs deviating from the personal law are protected even after the codification of personal law. For example, Section 29, Subclause 2 of the Hindu Marriage Act 1956 protects customs contrary to that. If customs and uses of Hindus are protected, then those of Muslims also ought to be protected. Hence, customary practices in Islam survived the Islamic Sharia Act 1937. The right of freedom of religion practices under Article 25, Subclause 2. My lord, I would also like to focus on that Muslim women are not discriminated against by the triple talaq rule and may even benefit from immediate relief from the bad marriages. There were the 4 advices from my side for the triple talaq. The number 1 is she may register the marriages under the Special Marriage Act 1954. Second, she cannot insert condition to the nikah nama to prohibit her husband from exercising a triple talaq. Thirdly, she delegates the right to triple talaq to herself, and finally insist on the payment of a high meher amount to deter the exercise of triple talaq. Thank you, my lord.
Mr. Sibil sir will continue argument on day 5.
My lord, I concluded by asserting that, irrespective of historical origins, triple talaq was now a core belief of the Hanafi school of Islam. I began by refuting the Union submission that triple talaq discriminated between Muslim women and Hindu women. Thank you, my lord.
Day 6, continue argument or court argument.
Law Board, urging that triple talaq is sinful and bad in theology, and yet insisting that the practice is an essential part of their religion. My lord, I also claim that Shariat Act 1939 was enacted only to override custom contrary to Sharia and urged that they codify and declare the Sharia as the rule of decision for certain subject matter. I also reject the All India Muslim Personal Law Board proposal to insert a condition in the Nikah-nama as the Dissolution of Muslim Marriage Act in 1939 requires Muslim women to go to court for a decree of divorce. Thank you, my lord.
My lord, under Islamic law, divorce is of primarily three types: talaq, which comprises of modes of divorce at the instance of husband; khula, which is a divorce at the instance of wife; and third is murabbat, which is mutual consent of divorce. My lord, he then clarified that talaq itself is of three types: talaq asal, talaq hasan, and both which are approved by Quran and Hadith. And the third type, which is talaq-e biddat, which is neither recognized by Quran and also not recognized by the Hadith. Under section 2 of Muslim Personal Law Application Act 1937, that makes to Indian Muslim does not include triple talaq or talaq-e biddat. That's all, my lord.
My lord, I argue that All India Muslim Women Personal Law Board to register under the Special Marriage Act would deny a Muslim man who can not marry more than one wife, which is permitted by Islam. I urge the court to ignore or overrule cases that have held that triple talaq is bad as per religious belief but valid in law, and do away with the practice of triple talaq protected under Article 25. So, my lord, I conclude by suggesting that Ronald Dworkin's institutional morality should guide the interpretation of the term morality in Article 25-26. Thank you, my lord.
My lord, I argue that personal law cannot be challenged under Article 14 as it requires a state's absent, which is absent in this case. I also want to state that laws in force under Article 372 is subject to Article 13, and that triple talaq cannot be tested on the annal of Part 3 of the Constitution. My lord, I also like to argue that divergence in Islamic interpretations ought to be overcome Islamia under Islamic law, and hence the court should be guided by how the community perceives triple talaq. So, my lord, here I conclude my asserting that All India Muslim Women's Personal Law Board is a legitimate organization which had 30 women members out of approximately 200 members. He confirmed that All India Muslim Women's Personal Law Boards will send an advisory to all Qazis to inform women of the options to insert a clause in their Nikah-nama to exclude divorce through triple talaq. Thank you, my lord.
As I believe that as far as the exceptions that are mentioned in Article 25(1) of the Constitution, this practice was not volatile of any exceptions as Sharif as Muslim. Personal law is not state legislation action. So triple talaq is an integral part of the religion.
Is against the Quran, hence it lacks legal sanction. What is held to be bad in the Holy Quran cannot be good in Sharia, and what is bad in the theology is bad in law as well.
Talaq-e biddat is regulated by the Muslim Personal Law Sharia Application Act 1937. This practice is unconstitutional because it is arbitrary.
I found that the practice of talaq-e biddat, commonly known as teen talaq, is essential religious practice. And that's why I found teen talaq is constitutionally valid.
Talaq-e biddat is regulated by the Muslim personal law, Sharia, application in 1937. They held the practice is unconstitutional because it is arbitrary.
As for the judgments, we are hearing all jury members' judgment. Please give any opinion of the who is the for or who is against the triple talaq. Is on your lights. Who is the for the triple talaq? The two is for the triple talaq, and who is the against about triple talaq? Please switch on your lights. Three is the against of the triple talaq. The judgment was given to the Supreme Court. The triple talaq is inconstitutional. Thank you.
Has held that the practice of triple talaq, that is talaq-e biddat, unconstitutional by a 3:2 majority. The court have finally brought justice to those women who have been a victim of triple talaq. The court also ensured that the ideas of equality, especially gender equality, are not mere theoretical ideology. And recently, that is on 30th July 2019, the Parliament of India passed the Act Muslim Women Protection of Rights on Marriage and declared the practice of triple talaq as illegal, unconstitutional, and also made it a punishable act from 1st August 2019. Thank you so much.
Judges who are sitting on the dais, advocates, our professors of law college and students of law college. I have seen a very great scenario today in the campus of Navjeevan that this play was arranged, and by this play, naturally our student will be benefited. What is the triple talaq? We heard since long that triple talaq case is going on, Shayara Bano's case is going on, but we were not knowing the facts, and just now the judgment has come of the Supreme Court that triple talaq is invalid. It is really work for the benefit of women, what I feel. And naturally our principal, she has a thorough study over this triple talaq, and I hope that this will help you much in future. Thank you. This play they have taken, our professors, they have taken much pain for performing this play, and the students, those who have participated in this play. Thank you.
Respected dignitaries, basically now today at present I am not standing as a principal, but I am standing as the subject teacher of family law. And when I was studying law, I always used to think that I used to go to National Law School, I will study there, I will go to Oxford, Harvard, and many things. But due to many situations, I could not study that. But being a teacher, when our Honorable Bhavesh sir have sent me to National Law School, Bangalore, there I studied one method of teaching, that is role play method. And this is that method which we are implementing every year. Last time we have tried for Warren Hasting's that murder case that we have seen.
Rajananda Kumar's trial we have seen in Now Law Fest, and this year Shayara Bano versus Union of India, the judgment was been given in 2017, but everybody knows that what was the repercussions of Shayara Bano. Not only this, the mystery of Muslim women, how family law has to be studied, how triple talaq has to be studied, what is nikah, what is marriage. So I am very happy and very glad to see such a role play method. It is a history today in 23 years of Navjeevan Law College. And wonderful scenario. As a subject teacher, I would like to thank Honorable Bade Sir, Honorable Bade Ma'am, our Shri Vijay Kare Sir, on behalf of management. He took time and was present here for this drama. Similarly, I also thank senior most faculty member Pandey Sir, Savarkar Madam, Meenakshi Ma'am, Priya Bhatpade Madam, Kiran Kshatriya Sir, Jeevan Bag Sir, Kokne Madam, Sujata Ozarkar Madam, our new family members, Vasundhara Chaudhary Madam, Rohit Mule Sir, our Mangal Patil Madam, Ulka Chauhan Madam, and each one of you who have participated here today. Definitely it is going to be a landmark thing, a history in Navjeevan's record. So congratulations to all of you. So now I request everyone to have a group photograph. And when Honorable Bade Sir, Bade Ma'am will be coming, we have to make a setup of meeting in 10 minutes, because as they will be there. So we have to be very quick, we need to take photograph. And on behalf of my first year students, I would request all the faculty members also, once Bade Sir, Bade Ma'am is been invited, they are also going to invite all of us for the program on 14th January, which is the freshers party. So after this, we are going to have the program. So let us have group photograph first.